So today I've got Alex with me from Catalyst Lawyers, and Alex is a conveyancer, lawyer, solicitor based down in Gold Coast, sunny, beautiful Gold Coast. And we are working together to improve home buyers' knowledge on everything around the legal side of purchasing a home. Alex, would you mind telling us a bit about yourself?
Oh, thank you, Nav. Yeah, my name is Alex Kiriakidis. I am originally from Canada. I came on the Gold Coast about 10 years ago to get my law degree. I went back to Canada and became a barrister and solicitor, specializing in civil litigation. I then got married and moved back to the Gold Coast and started my own firm called Atlas Lawyers. It's a little throwback from my Greek background, my love of Greek history and mythology, and the symbolism is supposed to symbolize Atlas, who carries the heavens on his shoulders. And when people do take on the legal issues, they look at them maybe as more burdensome than they are. And my goal, as if you can see at the bottom there, is to not only help with legal processes and legal issues, is to educate, which will then empower people and then guide them through the legal process. I have a special focus on conveyancing and property law, so that's why I'm here.
Brilliant. So today's topic, we're going to talk about the process of conveyancing. And as Alex said, that he likes to carry his customers' or clients' burden when it comes to the legal process. So tell me, Alex, what is the process of conveyancing?
Yeah, so let me start off by saying the process throughout Australia can be very different from state to state. I'll be focusing on Queensland. So the conveyancing process in Queensland, as in many things, is quite different and unique. But that's the focus that I'll be on for this topic. So what happens in Queensland is usually there is a contract of sale signed for property. That usually, in practice, doesn't go to a solicitor at all. There's a standard REIQ contract. There's others, but REIQ is the main one that we'll talk about. And that is usually drafted or filled in by the seller's agent or assisted with that. And there's some special conditions that may be put in that were agreed between the buyer and the seller. But when that happens, then myself as a solicitor, as the buyer or the seller, would get that contract directly from the agent. This way, once there's a signed contract in Queensland, there's still, I call it the conditional period. There's the standard conditions that take place. That would be, there's the cooling off period, the building and pest, and a finance condition. Those would usually be the standard ones. There's various ones. It all depends. Remember, these are contracts and agreements that connect one person to another. It depends on the specific property as well, if there's any specific concerns. Once those conditions are satisfied, then I would call it the unconditional period. There's searches that are done that technically should be done at the beginning of the contract or anything, but a lot of the times in practice, we do them once it's unconditional, just because you don't know. You can terminate a contract in this conditional period and both buyer and seller go their separate ways, and you don't want to spend more money than you need to get to settlement. Once you do those searches, now in Queensland, it's very important. There's very minimal disclosure required. So it's really buyer beware. So a lot of burden goes onto the buyers. Once you do those searches and you're able to get the results that you need, one of them would be the rates and water search to kind of account for and apportion for the amounts of rates and water that have been paid up to the settlement date, and taking into consideration any deposits and everything that's paid. A settlement statement will be drafted. Documents will be exchanged, the formal documents that are drafted by both parties for the transfer documents. And those all get presented at settlement along with bank checks. If it's physical settlement, if it's through e-conveyancing PEXA, then electronically. And then settlement day happens. A lot of behind the scenes activity goes there, but then once everyone shakes hands and everything, then settlement takes place at that stage. So as I mentioned, the REIQ contract, The Real Estate Institute of Queensland, they have their standard contract, which most people use. There's a standard terms and conditions, but a lot of it comes from legislation, which is just codified. But it's very important to know the terms and conditions going back. Now, very important as a buyer to focus on, to remember to pay your deposit on time. People don't realize the importance of it, and you think it's just something minor. Yeah, I'll do it. Deposit is a significant aspect of the contract and of a land contract. So I put some points up there in what the courts and the judges have mentioned and found what a deposit is. It serves as a guarantee for the performance of the buyer. It serves as money to go against the purchase price, so it'll go lower. And it's basically the intention of a buyer to purchase the property, to make a contract really valid, rests on the deposit. And if people don't pay the deposit on time, that can basically be that can be reasons for a seller to terminate. So very, very important, although it seems minor, to know the dates and the times where you have to pay your deposit, and do pay them in time. And if not, communicate with your solicitor that I'm going to be paying this. Can you please mention it to my solicitor, the seller's side? So I can't emphasize that more because, again, many people don't think it's a big thing. And it doesn't seem like it would be in the whole scheme of things, but it can be fatal to a contract.
Can I ask you something, Alex? Is there a minimum deposit requirement by law that a buyer has to give the vendor when signing a contract?
There's no minimum. It's based on agreement. Standard practice would be 10%. However, I usually tell clients if that does become an issue, to give a significant sum as a deposit. First, you pay maybe $1,000 deposit. Again, based on Queensland, we have that unconditional period. So a lot of contracts are maybe stacked in a way where you pay $1,000 deposit, and that makes the contract formal. And then the balance of the deposit, maybe 2 days after, it goes unconditional. So that's quite common in Queensland. What's more helpful is maybe some buyers say, well, there's $50,000 to be put down as a deposit. That seems a little bit excessive to have it sitting in a trust account, especially for maybe longer period contracts. So what I tell clients is, well, it could be a decent discussion with the seller's side or even the seller's agent. A lot of times, both sides can agree to say, well, as long as there's a decent amount, maybe $10,000, $15,000, $20,000, enough to cover the agent's expenses, I think all parties are usually happy to have that amount.
Okay.
And so there's no set in stone amount. 10% is the actual the convention, but it's not required.
Okay.
All right. So here we go and talk about building and pest. This is a common one in Queensland. I always tell people, when in doubt, you never know what's in the property, and you don't know what's going on. And remember, in Queensland, buyer beware. It could look like a beautiful house. You have some live termites eating at that are behind the walls, eating at it and causing structural damage that could cost you significant amounts of money in the long run. It'd be important to know about that before you go unconditional.
So those are quite important. Is it important for a buyer to ensure that they do, especially when buying a freestanding property, that they get building and pest, so that if there's a recourse, they can apply it to the building and pest inspectors' liability?
Yeah, so not necessarily, well, so the question is about the if there's building and pest, if there's something that's found. So is there
a recourse for them if they do a building and pest inspection and
throughout the contract and yeah.
Correct.
Well, absolutely. I mean, although it's buyer beware, as a buyer, you have great leverage in this conditional period if you do find something significant, you can either terminate and get your money back based on the building clause or pest clause. But you can also negotiate with the seller, because the seller still might be willing. They might be aware of those issues, or maybe unaware of those issues, and they still want to sell the property and are willing to take a hit to it. What I usually tell my clients, again, it's all with agreement. Try to get a couple quotes, find out, so then you can have a reasonable negotiation. You don't want to just throw out a massive number without anything and saying, deduct this from the sales price and then I'll settle. If you have a quote, that allows you to have a reasonable negotiation with the other side, so you can take away, there can be, if you can appreciate, a lot of emotions involved. Sometimes a seller might get unreasonably upset if you want to deduct the amount. But if you back it up with a quote, that can kind of mitigate that situation where, let's talk business, this makes sense. We have a quote for $5,000. They're asking for $5,000 off the price, as opposed to they just don't want to pocket that $5,000. So that usually keeps the deal alive and makes both parties happy and actually reach a settlement. Settlement day. Well, this is, again, once we go unconditional, there's a lot of things that happen. There's the settlement statement, as I mentioned before. Per the terms of the contract, you are required to apportion for, as a buyer, you might move into the property or own the property with a credit paid out to the council, paid out for water and for council rates. So that's quite important to know and to offset that to the seller. Or you might come in with a debt, and you want to make sure that you know that. That's why you do those searches. And then basically you even it out, both solicitors on the other side fix that up. There are transfer documents, and in Queensland we still do paper settlements, so quite important to have those. They seem quite simple. They're a few pages, but quite important to have those drafted properly, because if they're not, without the proper documents attached, they won't be accepted by the land titles registrar. And if they're not, and if you paid for a property, you've gotten those documents, they're not drafted right, you might have some trouble getting your name on title if they're not drafted properly, and then it just causes much more issues. So you got to be concerned about that and make sure that that's done properly and detailed. Exchange of checks. When you are using a lender, there is definitely, they require, you should know how many checks will be made out, how much money you're going to be contributing as well. If it's a paper settlement, as I said before, there may be some bank checks that may be required to be produced by you yourself. You pay into your solicitor's trust account, they can deduct that amount as well. But all the amount, the final number is basically comes out at the settlement statement after all the searches are done. It seems quite simple, but when time is of the essence, as it is in Queensland, things get very condensed. And especially when you cut down the time from the unconditional period to the time of settlement, all these things are trying to be tied in as quickly and as efficiently and as accurately as possible. So very important that you get a proper solicitor or communication, at least, to get these things done. And that's our goal. That's everyone's goal. That's my goal. I know that's your goal, Nav. We are in, my background before I did civil litigation, and I was dealing with people fighting all the time. I don't want to fight. I want to see someone happy. They're one of the biggest purchases, if not the biggest purchase in their lives, to be as stress-free as possible. And conveyancing may seem, the word conveyancing may seem, oh, okay, it's just going to be from A to B, contract was signed. It can be quite stressful. And the goal is from all of us professionals on our end to have our clients have as stress-free life as conveyancing process as possible.
Well, there is a contract involved, right? And contract is a legal document. So it would be a wise choice to engage a legal expert to overlook the contract before the transaction actually goes through. Yeah, like you mentioned, going back slightly, you mentioned in Queensland time of the essence, and that's typically because in Queensland a contract is a 30-day contract. Now, earlier on in your slide, you also mentioned something about financing. Now, in your experiencing, is it wise for people to, go for a 14-day finance period, or should they try to stretch it out to 21-day finance period?
Now, it's all dependent. I always talk to my client, and I also try to have a good relationship when I represent the buyer. I always have a good relationship with the broker and the lender, and to see, well, how many days do you need? What's going on? There might be some extreme circumstances like COVID-19 where, you know what, the processes might be taking longer. So it's better when you're negotiating that contract to ask for maybe 3 weeks. But it also depends, because I don't want to break the deal for a potential buyer if the seller has other potential buyers that are willing to have a 14-day contract. It might make it less attractive, in other words. So there's a lot of elements in play there that might be different for different people. Always, as a lawyer, we're